is looking into offences that were committed, several offences, including arson, malicious damage, stealing, among other offences that were committed during the protest. And the issue has been raised concerning the investigators' affidavit. And while the councils are raising issue with the commissioning of the document, I have not had any issue being raised as to the content of that affidavit. The officer is present in court. He can make the apartments on both. And the defense have not requested for any opportunity to cross-examine the investigating officer on the content of this affidavit, which is filed before you. So my argument, Your Honor, is that let us not be swayed by technicalities, but by the substance of the application that is before you. Yes, and the officer is in court. Should the court, if the court would like to inquire anything as to the contents of the affidavit, it can be placed on oath and examined on the same. So the defense has tried to raise other issues, making political, indicating, trying to indicate that this case is has political influence. I'd like to reiterate that nothing to that effect has been raised by the investigating officer in his affidavit and his application. He's not investigating into the circumstances of the JR application or the impeachment of one of the suspects. His investigations are limited to the offences committed on the 25th of June, 2025. The main issue that we have raised, the issue of interference with witnesses, is a compelling reason, not just a reason, a compelling reason not to have the suspects out on bond. And from the application, it is indicated that the two suspects were seen handing out money to groups of youth who we expect to record as to record their statements as witnesses. Being in positions of influence, it is very evident and a great likelihood that they will interfere with these witnesses. In such applications, Your Honor, it is not mandatory that for the investigating officer to provide the names, considering that the case is at investigative stages, and also to protect the identity of these witnesses. It is not mandatory that their names be published in the application. Once the matter is concluded, discovery will be done at the appropriate time if and when the decision to charge is made against the suspects. We'd like the court to appreciate that the matter is still at investigative stage. We'd also like to confirm that investigations have been ongoing from the date of commission of the offence. The suspects have been availed in court within 24 hours of arrest. Therefore, their rights as arrested persons have not been breached in any way. And that is why we are here before you under making an application under Article 49(1)(h) for the extended detention. So we request that you allow this application to preserve the integrity of the investigations that are ongoing, which, as we have demonstrated to the court, are quite extensive. That's why we have requested for 21 days. That's all you want.
How do you see the issue of your competence of the affidavit?
It's not fatal. I addressed that first, indicating that it is not fatal. We have the officer before you, and his arguments can be put to cross-examination. We have requested the court to consider the substance of his application